Hello, beautiful people. Welcome to Global Happenings today. It looks like Nnamdi Kanu will be enjoying a lot of leverages on technicality issues over his detention and prosecution in Nigeria concerning the indigenous people of Biafra on treasonable felonies and other cases. As we speak right now, his lawyer, special counsel to Nnamdi Kanu, is beginning to speak up on some of the technicalities why Nnamdi Kanu cannot and will not be, convicted. Well, it looks like he has done his background check. We're going to give, in a moment, we're going to see the lowdown of why Chineke, as Ifeanyi Jofo will always say, may have every reason to jubilate at the background. Before we go into the newspaper, I'd like you to subscribe to our channel by clicking on the red subscribe button beside it. You see bell notification icon, please go ahead, click on it to get notified as soon as we update our channel on YouTube. Quite a long read. Let's quickly hit it running. Well, Alo Ejimako, special counsel for the detained leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, on Monday said that Nigeria cannot properly levy its sovereign right of criminal prosecution against his clients because the federal government has not explained what it meant by Kanu was intercepted in a foreign country. In the press release obtained, Ejimako insisted that Nigeria must first explain to her domestic courts and the international community, particularly Britain, how Kanu ended up in a country in chains. The lengthy statement was titled, "Absence of Lawful Extradition is the Reason Why Nigeria Cannot Explain How It Intercepted Nnamdi Kanu." Kanu, 54 years old, was born at Afaruku, Abia State. He had earlier left in June 2018 before leaving for the United Kingdom, UK, his second home, though he said that he fled because his life was no longer safe in Nigeria. After about 3 years abroad, the Attorney General of the Federation and Minister of Justice Abubakar Malami, Senior Advocate of Nigeria, at a press briefing in Abuja on June 29, 2021, announced that the indigenous people of Biafran leader was rearrested in a foreign country and extradited to Nigeria. His lawyers had said the indigenous people of Biafran leader was abducted in Kenya and whisked to Nigeria. Upon his rearrest and extradition in June 2021, he was rearranged before Justice Binta Nyako for terrorism-related charges and has since been remanded in the Department of State Services, DSS, in Abuja. He has been brought to court several times since last June. With his matter stilled, the case was adjourned till February 16 for trial. Following the sudden appearance of Nnamdi Kanu in Federal High Court in Abuja on 29 June 2021, the Attorney General of Nigeria, Abubakar Malami, Senior Advocate of Nigeria, at a press conference on the same date, stated that Kanu was intercepted through collaborative effort of Nigerian intelligence and security services. He added that recent steps taken by the federal government saw to the interception of the fugitive Kanu on Sunday, the 27th day of June 2021. Beyond this bland use of words interception, neither the Attorney General nor any other Nigerian official has explained how and where this infamous interception occurred, or whether it occurred under the pertinent legal framework or not. From published accounts, all effort by the media, domestic and international, to elicit details of this interception have met a stubborn official silence. And it appears that the same is true with myriad diplomatic inquiries issuing to Nigeria from international community, notably from the United Kingdom and the United Nations. Conversely, Nnamdi Kanu had, in various sworn statements, given credible account and details that prove that the so-called interception is simply that he was officially kidnapped, disappeared, tortured in Kenya, and extraordinary renditioned to Nigeria. During the hearing of Kanu's fundamental rights suit in Abia State, which he won, the Nigerian government could not explain how Kanu ended up in Nigeria, thus confirming that Kanu was not extradited but illegally renditioned. If Kanu was extradited, the Nigerian government would have been very forthright with it, especially given the insurmountable persecutionary barriers that comes with extraordinary rendition. It is therefore instructive that To date, the Nigerian government has neither in court or public contradicted Kanu's account nor offered any alternative account that may suggest that Kanu's return to Nigeria was secured through some due process of law. On its part, the Kenyan government has in the public and in processes filed in court vehemently denied that Kanu was subject to any extradition or even deportation proceedings in Kenya, and Nigeria has deadpanned to Kenya's self-righteous denials. In view of the foregoing, there are several questions and answers well-meaning Nigerians and the international community must demand from Nigeria. These questions and answers are very crucial because under the domestic and international legal order, Nigeria cannot properly levy its sovereign right of criminal prosecution against Kanu without first proving that the act of transferring Kanu from Kenya to Nigeria conformed to the basic tenets of the law, municipal and international, including particularly treaties which Nigeria is subject. As a sovereign nation and a member of Committee of Nations and a country with a constitution and laws, Nigeria must first explain to our domestic court and international community, particularly Britain, how Kanu ended up in Nigeria in chains. This is but a basic condition precedent without which prosecution of Nnamdi Kanu cannot ensue. The whispering notion that extraordinary rendition is but a concept in international law that does not apply to Nigeria is false, and it borders on crass ignorance. The Nigerian Constitution provides in its fundamental right at Section 35, subsection 1, that no person shall be deprived of his liberty save in accordance with a procedure permitted by law. The operative phrase here is procedure permitted by law. If there's absence of extradition proceedings in Kenya for Nnamdi Kanu, it means that the deprivation of his personal liberty, the interception and detention was not in accordance with procedure permitted by law. At law, such gross misconduct must surely complicate any criminal prosecution by the complicit state. A lot of people might not be aware, but there's a Nigerian law enacted by the National Assembly in 1983, known as the African Charter on Human and People's Rights Ratification and Enforcement Act. You can see this in law at Cap A9, Laws of Federation of Nigeria 2004, Article 12, subsection 4 of this law provides that a non-national legally admitted in the territory of a state party to a present charter may only be expelled from its virtue of a decision taken in accordance with the law. To be sure, Nnamdi Kanu, a non-national of Kenya, was illegally admitted to Kenya on 5th May 2021 and then expelled and was transferred from Kenya to Nigeria on the 27th June 2021 without a decision taken in accordance with the law. Both Nigeria and Kenya are state parties to the parent African Charter that grandfathered the similar law Nigeria later domesticated into its municipal laws. Accordingly and additionally, the Mutual Assistance in Criminal Matters within the Commonwealth Enactment and Enforcement Act, another Nigerian law, clearly specified as Section 4 to 6 the procedure that must be followed in any situation such as Kanu's case, where Nigeria is requested assistance in a criminal matter or a fugitive from a Commonwealth country of which Kenya is one. The procedure strictly requires the consent of the state of the refugee where such fugitive is found. In particular, Section 6, subsection 5 stated clearly that the provisions of the Section 4, 5, and 6 of this Act shall apply mutatis mutandis to any case in which Nigeria is either the requesting or requested country, as the case may require. Thus, before Nigeria can prosecute Nnamdi Kanu, it must show that it complied with provisions of this law. The continental version of the earlier mentioned African Charter on Human People's Rights, which Nigeria ratified and is thus thereby bound, provides at Article 6 that no one may be deprived of his freedom except for reasons and conditions previously laid down by law. In particular, no one may be arbitrarily arrested or detained. Given that Nigeria claims that it intercepted Kanu, the question that arises is whether the said interception amounted to arbitrary arrest and detention. If it did, then no prosecution ensuing therefore can stand in law. The same African Charter provides in its principles and guidelines on human and people's rights while countering terrorism in Africa at Part 5, Subsection A, transfers of individuals that a state may not transfer, example, deport, expel, remove, extradite an individual to the custody of another state unless it is prescribed by law and in accordance with due process and other international human rights obligations. Deportation, expulsion, and removal cannot be used to circumvent criminal justice processes, including extradition procedures, extraordinary rendition, or any other transfer without due process is prohibited. With particular reference to the preceding paragraph, what immediately jumps out is the phrase extraordinary rendition or any other transfer without due process of law is prohibited. Since Nigeria is, by treaty, bound by this, it should be guided by the celebrated case of General Sani Abacha versus Gani Faweyimi, where the Supreme Court held that where a treaty is enacted into law by the National Assembly, as was the case with the African Charter, it becomes binding and all our courts must give effect to it like all other laws falling within the judicial powers of the court. Further, in anticipation that an African state could commit extraordinary rendition, such as Nigeria has done to Kenya, the African Charter principles and guidelines on humans and people's rights while countering terrorism in Africa at Part 1, Subsection 5, provides that states shall provide full and effective reparation to individuals who have suffered violations of their human rights as a result of acts committed in the name of countering terrorism. Full and effective repatriation should include restitution, compensation, rehabilitation, satisfaction, and guarantee of non-repetition, as the charges leveled against Kanu indicate Nigeria justified its interception of Kanu in the name of countering terrorism. On what constitutes restitution, the United Nations Basic Principles and Guidelines on the Right to Remedy and Reparation of Victims of gross violations of international human rights and serious violations of international humanitarian law provides in Part 19 that restitution should restore the victim to the original situation before the gross violations of international human rights law occurred. Restitution includes restoration of liberty and return to one's place of residence. Nigeria is, by virtue of being a member of United Nations, bound by these provisions. In view of the ongoing, it is treated that a renditioned fugitive suspect cannot be subject to trial. Thus, Mazi Nnamdi Kanu should be restituted or restored to the status quo, whether to Kenya or Britain at its option. It is inherently contradictory to postulate that a rendition suspect will get a fair trial from the jurisdiction that renditioned him. By its infamous nature, extraordinary rendition destroys every prospect for a fair trial. Therefore, the next best thing for Nigerian authorities to do is to do the part of honor and contrition by releasing Nnamdi Kanu unconditionally. In the interim, it may choose the earlier option of forbearing any objections to reinstatement of Nnamdi Kanu's bail, which will instantly clear the judicial path to his release. Going forward, the authorities can be guided by the recent judgment of the Abuja State High Court, which exonerated Kanu from the supervening event that disquieted his bail and ultimately culminated in the extraordinary rendition. Hey, this one is, let's just meet in our commercial session. If I have gone to get